SJC-13855, Commonwealth versus Feng.
Okay, Attorney DeMayo.
Good morning. May it please the court. Christopher DeMayo for Shu Su. Trial counsel Deborah DeWitt is with me. So this case involves a confluence of factors that led to the wrongful conviction of Ms. Su. It's a circumstantial case. It's a very emotional case because it involves an infant, and we've all seen the videos of Chloe Chen and scooting around. It's very sad to watch those videos and know that she died shortly after. It's human nature to want to find a precise answer what happened, and it's really human nature to want to blame somebody. The third factor is that the defendant here, as in a lot of these cases, was a bit unsophisticated, at least in terms of her English usage. She had graduated from high school several years before, it lived at home speaking Chinese. And I guess the fourth factor that contributed is that this is a case that turned a lot on expert witnesses. And expert witnesses, this court and others have recognized, they tend to get jurors to defer to them more, to forego their own independent analysis. So those factors will recur throughout what I'm about to say. I'll take the two issues that are in the brief in order, beginning with the sufficiency. The real crux of the evidence here for the Commonwealth is that Ms. Su was the last caregiver. She was the last person there. That's generally a problematic inference for the reasons the amicus note, but in this case, it's specifically problematic because we know, with the benefit of hindsight, that Chloe had neomembranes, at least one, maybe two, in her head. We know those can rebleed. Dr. Halsapple, the surgeon, could not rule out a rebleed. He said he didn't think it was one because he saw a lot of acute blood, but he wasn't sure it was possible. And all of the witnesses, including even Dr. Schwartz, the Commonwealth's witness, acknowledged that there can be lucid periods between the time of a head injury and the time of onset of symptoms. So you can't infer necessarily that whatever happened immediately before Chloe presented at the hospital. The other piece of this is the thumps, the video with the thumps on clip 25. I would submit that the Commonwealth didn't really believe in its theory. The Commonwealth's theory of the case was that Ms. Su battered her niece 11 times against a wall, and resulting in the injuries. I would submit the Commonwealth didn't really believe in that enough to make any effort to tie that video evidence to the medical evidence. There was none of the doctors were questioned about the thumps. None of the doctors were questioned, did she present in a way consistent with being battered 11 times against a wall? She presented atraumatic except for one small bruise. So I think you can kind of guess what the answer to that would be. And then going the other direction, from the audio to the medical presentation, there was no evidence there. There was no evidence that, this, from an acoustic expert, this sound is characteristic of a body hitting a hard object. Nothing like that. It was all left to the jury, to a lay jury, to make the inference. And I would submit here, it was not a reasonable inference for a couple of...
Dr. Shaw testified that, as an opinion, that the blunt force injuries to the head caused by a significant level of force caused the baby's death. Is that not enough tie to the thumps?
Well, I guess everyone, even our expert, agreed that there could have been blunt force. She said it was in the past. So the issue is really the timing. And the Commonwealth's theory of the case, which they're bound by, was that Ms. Su had battered this child shortly before the 911 call 11 times against a wall. And I'm submitting that Dr. Shaw was not asked about that. He said blunt force, but he was not asked, was this, and he saw the baby, he saw unfortunately, by the time he did the autopsy, it was in rough shape from the CPR and from all the intervention. But the people who saw the child present, like Dr. Gutierrez and the others in the ER, they weren't asked about this. There was no effort. Is this a plausible theory of the case? This child was battered 11 times.
But just sort of putting your Commonwealth hat on, if you may, because we view the evidence in the light most favorable to the Commonwealth on a sufficiency of the evidence objection. Why is there not enough? And understand that, that there were arguments, and the defense, I think, was entirely that this had happened, based on the prior injury, or maybe just not enough evidence of blunt force trauma to the head. But there was definitely evidence that the Commonwealth could rely on, a jury could rely on, that it was, in fact, the head trauma that caused the death.
Well, the medical evidence itself was equivocal because of what I quoted about Dr. Hulzapo, which was that I think this was I don't think this was a rebleed, but I can't say because you do see rebleeds that look like this. So it seems to me that rules out just the medical evidence getting them past the Lattimore bar. It comes down to the thumps. It seems to me that you have to use the thumps to tie this all together. And we have a lay jury here.
Lay juries can interpret thumps. It doesn't require a lot of expertise to interpret thumps.
I disagree.
Really?
This court in the
can't lay jury's been presented testimonies saying that they heard 11 thump. When they see the child behaving normally, then we have 11 thumps, and then we have a doctor's testimony saying that blunt force. The jury can't make those connections in the light most favorable to the Commonwealth?
There's some evidence that is too low quality to be a basis for a reasonable inference. And
I'm sorry, I didn't hear the word too.
there's some evidence that is too low quality. And I'm thinking in particular of the Davis case, which one of the amicus cite, which involved a fuzzy video, and the prosecutor asked the jury you could see a fuzzy image of a black male, and the prosecutor asked the jury to infer that it was in fact the defendant. And this court said, no, that's not a reasonable inference because it's fuzzy. There's just not enough there to draw a reasonable inference from. I would say this video clip with the thumps, I don't know what they mean. I listen to it on headphones. I hear those thumps. I hear other noises. I don't know what they mean. And it has to be a reasonable inference. And I guess I'm suggesting it's not just unreasonable. It sort of requires a suspension of disbelief that this happened, as the Commonwealth's theory, that she battered this child. There's not a bump. There's not a cut. There's no damage to the wall. There's no blood, no forensic evidence, no hairs in that room, which they searched.
Can you tell me more about the bruising on the child's head?
All we know is that there is a bruise that was not swollen, and it was apparently small enough that some of the doctor witnesses didn't even recall it, but it was there because some of them.
There's at least medical testimony in the light most favorable to the Commonwealth that the child suffered from blunt force trauma.
Yes.
And we have thumps.
You have thumps and you have a bruise, but the question is, could that bruise, again, the Commonwealth is bound by their theory of the case. That's what this, I think it's the Fragata case that says that.
Address the legal.
Yes, I'll get to, yes.
So
Yes, I will. But their theory of the case was that it was this battery 11 times, and I would submit that one old bruise is not, this case compares unfavorably to virtually all the last caregiver cases, which I put in the blue brief. In the Roman case, which I cite as sort of the dividing line in last caregiver cases between what is sufficient and what's not, and I would submit this falls on the side that goes for a directed verdict. All right, I'll speak now about the abusive head trauma diagnosis. The gist of our argument is that it's not a medical diagnosis. It's not helpful to the jury, and it, in fact, usurps the function of the jury.
Isn't it a diagnosis in the peer-reviewed articles that the motion in limine judge relied on?
When I say it's not a medical diagnosis, I guess let me be more precise. Dr. Schwartz was not involved she was not in the ER or the operating room or the ICU. She got involved in this case after Chloe had been treated. Therefore, unlike all the other doctors who were testifying firsthand to things they saw and did, she went and talked to all the same people who testified at the trial. She talked to the ER people, the ICU people. So everything she said is derivative.
What does that have to do with a medical diagnosis? We have medical diagnoses all the time from expert witnesses that are post-trauma, post-mortem, post-everything, and we still allow them in as diagnoses. The fact that this person had hearsay information, et cetera, has nothing to do with whether or not it's a proper medical diagnosis. I don't get your argument whatsoever.
Well, so what I'm saying here is that everything.
If that were the case, no, there's no forensic testimony at all. None of your experts could come in and say he has schizophrenia, if that were the test. So please.
All right, so what she did was she gave testimony that is derivative of everything that the jury had already heard from those same exact people. And I would submit it's not simply cumulative. She sort of embellished it a bit, which, and I'm going to give the example of Dr. Holzapfel.
So is your argument that Schwartz in particular in this case should not have testified?
Right.
Or I thought your argument was broader, that abusive head trauma should not have come in under the Daubert-Lanigan standard, and maybe something about the word abusive. I'm confused now because you're focused on Schwartz doing something in real time as opposed to the arguments were on your brief.
I understand, yeah. So I was just trying to show how in this particular case, it had the effect of taking what other people said and embellishing it slightly. So for instance, the key here was—
Your word is embellish. Other words might be providing expert opinion on.
No, I think the right word is embellish. Dr. Holzapfel said, I can't rule out that it's a rebleed. I think it might be.
So can we get to the core of the argument on abusive head trauma?
Yes.
Okay, thank you.
But before you get there, can you just address the specific thing? Are you saying that AHT is categorically inadmissible, or that this record fails Lanigan? Because I can't figure out what you're saying.
So this brief, I focused on what I would call the Tanner-Canty argument, which is that this is not helpful because she's simply diagnosing abuse, which is tantamount to diagnosing a crime, because abuse implies a violent act with intent. That was the basis of the argument I made here, because I thought that was very clear from this record. There is a broader argument, which was raised below and which is in the record, that there's simply not a scientific basis for any of this to come in.
Are you waiving that second argument now? Because that's why we took the case. So just trying to understand, are you backing away from that?
Not at all, no. I'm focusing, so if I think that there's two separate issues here. So there's the issue of, is there a basis, a scientific basis for the theory that you can shake a baby and break its veins? And then there's this other issue about—
Well, there's a science. Can you give testimony on AHT and if so, is the proper formulation of it consistent with AHT because of the problems related to the word abusive, right? Those are the core issues that we were hoping you would deal with.
Yes, no, I was trying to get there. All right, so yes, this certainly was a vehicle to use the word abuse, which is problematic in itself, and which Attorney DeWitt tried to keep out. But the problem I have, and this is what I was saying before, is it allows someone like Dr. Schwartz to take all the same evidence that the jury has heard and to diagnose abuse, which is it's more than simply touching on an ultimate issue. It's actually opining on guilt in this case.
But then that gets to the second part of it, which is that Judge Wilkins required it to be presented as consistent with, not making that ultimate determination. So that seems thoughtful. Is there something wrong with the way he did that?
Well, I think, as the amicus point out, and as the appeals court said in Tanner, juries don't really parse things that fine in terms of whether it's consistent with. You hear consistent with, and you might think because of, or inconsistent with, not because of, which was an issue with the shortfalls. there was testimony that shortfalls are inconsistent with fatal hematomas, which suggests they can never happen, but that's not the case. So there's a lot of evidence, and it's in the Amici brief, that you can't cure this simply from saying inconsistent with. It's still going to the ultimate issue. And I'm running out of time, but the broader issue, so this was a case that didn't involve.
But before you leave that, because again, my recollection of Tanner is consistent with, it's not that the appeals court has rejected that, rather the appeals court has required it. So I'm in the drunk driving context, right? So what's wrong with consistent with, and doesn't that sort of manage the danger that comes from the word abusive?
No, the problem we have here is that the expert is being allowed to opine. Even in the drunk driving case, say Canty, this court has always required that the expert has to stop before reaching the ultimate. The jury has to be able to take that last final step, even if it's a short step, like in Canty, from he was very intoxicated and in a car to, and then the jury decides he was too intoxicated to drive.
What about when the defense expert testifies the person was not criminally responsible because they didn't know the wrongfulness or the ability to control their conduct, the requirements of law? Is that permissible?
Well, that's an interesting example. In general, though, I would say, I haven't thought about that one, but in general, we don't, that's not really an opinion on guilt. I mean, it's an adjunct to it when you raise a criminal, but we're not, we do not generally allow experts.
Sorry.
Go on, I'm sorry.
No, please answer Justice Gaziano's question.
I think he's done.
Oh, is the problem here, in your view, just the use of the word abusive? If they had used, if the judge had required that it just be called, the diagnosis be called head trauma or external head trauma or repetitive head trauma, in other words, something that doesn't characterize it as abuse, what would be the problem?
Well, Dr. Shaw, the medical examiner, had already testified that it was caused by blunt force injury.
Okay, so it would have been repetitive, but that wouldn't be a legal error, really. It would have been repetitive. That's the problem?
No, I'm trying to draw a distinction. That was permissible because that's a factual statement about what happened here, that it was blunt force. And we can disagree, and Attorney DeWitt can cross-examine him about how he knows when it happened. But abusive head trauma, I mean, that again, abuse connotes not just the violent act, and blunt force trauma doesn't necessarily mean violence, it just means blunt. Abuse connotes a violent act, and it connotes
okay, so it does all, in your view, it does all come down to the problem of the word abuse, or abusive.
Well, that's part of it, but I mean, it's what I was trying to say before was Dr. Schwartz's testimony, it was all derivative of the same things that the jury heard. And I appreciate that sometimes experts, they can rely on hearsay, they can rely on other people, but the effect of it in this case is she took everything the jury heard, she kind of regurgitated it. So it sounded better. For instance, Dr. Holzapfel said he wasn't sure it was a rebleed. He couldn't rule it out. In the words of Dr. Schwartz, she was asked, was this consistent with the rebleed? And she answered, no, it's not.
She wasn't repeating.
But we know but she admitted that her entire opinion is based on her conversation with him.
But can you clarify for me? So I get your argument about the word abusive and abusive head trauma as a diagnosis, and we may quibble whether or not a diagnosis is possible. Two questions. One is, and I think someone asked you before, Justice Wilkins or Judge Wilkins relied on the peer-reviewed articles. Are you saying that AHT, if we took out the A, right, if the head trauma diagnosis, is admissible pursuant to those peer-reviewed articles under Daubert-Lanigan?
No.
Why not?
So, all right. So as I understand it, there's sort of a core to the shaken baby syndrome diagnosis that goes back decades, which is that you can just shake a baby to
I read
death.
I read the Neves case that was cited, right?
Right.
The Jersey decision.
Right, that was a shaken.
Right, but that exactly. So that to me seems like it's not this case, because in our case there's blunt force trauma as opposed to a pure, and these are horrible terms, but a pure shaken baby case without external trauma. Correct?
Correct.
Right.
All right, but so my argument is, so the reason I focused on the Tanner, what I'm calling the Tanner-Canty argument, which is more about the expert usurping the.
That goes to the word abusive in head trauma. The whole issue, though, I thought we had before us was whether or not it was legal error for the judge to allow any testimony at all on abusive head trauma or this blunt force head trauma in these cases, because doesn't satisfy Dauber-Lanigan. Is that not the argument?
My argument is the argument I've been making, which I was talking about with Justice Wolahogian, is that it doesn't satisfy the first prong of Rule 702. It's not helpful to the jury. It's going beyond simply stating a fact, like Dr. Shaw, the medical examiner, did blunt force trauma. It's simply characterizing it in the way that
But there's a phenomena that's associated with abusive head trauma that's beyond just the negative word abusive. There's also the injuries. I know you quibble about them, but they're the constellation of injuries that are apparent to the head in a young child. You're suggesting that evidence isn't helpful to a jury? The retinal damage, etc.?
I don't see how the retinal damage, certainly all of that could have been argued by, all of that could have been put into evidence with the actual treating doctors and argued.
You don't think that's beyond the pale of a jury, that they need to know that of the counter-coup injuries, etc., that happen with particularly to an infant?
Well, now we're getting into the sort of core of the shaken baby syndrome. And no, I don't think for all the reasons that are in the Neves case and that the amicus brief cite, I don't think they should hear that, because there's very many things that can cause dural bleeding and that can cause retinal bleeding and that can cause brain swelling. We saw them in this case. I mean, rebleeds can cause a hematoma.
When we dealt with this in Million and Epps, we also said it's important to hear both sides of this very complicated issue.
That is true. That was 10 years ago. A lot of this obviously turns on the biomechanical studies, which have been ongoing in the last 10 years and which the Neves case cites, because ultimately.
And Neves involved no suggestion of blunt force trauma to the head.
But I guess I don't see how that can help the Commonwealth.
Well, it
here.
helps. Well, I don't know if it helps or harms the Commonwealth. I guess my question is, how is Neves helpful to you in terms of your argument that it's a biomechanical phenomenon, as opposed to the testimony that we have here of a blunt force trauma? Schwartz putting all together what Stanley said with what Shaw said and saying, this is consistent with AHT.
What Neves, I think Neves calls into question the whole idea of shaken baby, and I'm taking both the shaken baby and abusive head trauma part, that you can simply rule out and exclude a few things. And then if there's a presence of brain swelling or retinal hemorrhaging, you can assume that it is from shaking or from abuse. And the problem isn't so much the differential diagnosis or the ruling out, it's what you're ruling in. If you can't, just because you eliminate some things, you can't rule in something that's physically impossible. And the argument is that it's against the laws of physics that you can do these things, that you can tear subdural veins just merely
With
by
a
shaking.
blunt force trauma to the head?
With a blunt force trauma to the head, you can. And
I'm sorry, you can or cannot rule it out?
This is why my argument is that this was not helpful to the jury. As I argued in the brief, jurors know that if, in fact, this transpired as the Commonwealth said, and Miss Sue somehow she managed to beat this child against a wall 11 times without more than one old bruise, they will know that's bad for you. They will know that Dr. Shaw found that there was blunt force trauma. They do not need Dr. Schwartz to come in and act as a second jury, listening to all the same people that.
Well, isn't I thought that the Commonwealth was making the point or the argument that it is helpful because the baby did present with very limited externally visible injuries, which is not consistent with one's sort of maybe potentially a jury's sort of common understanding, and only had a very small bruise. And so the testimony regarding AHT/SBS as a broader framework was helpful to the jury in understanding how someone could have such significant internal injuries without external injuries.
But that's just what Dr. Schwartz did not explain. That would have been helpful. If there is a way to beat someone's head against a hard object 11 times without leaving a cut or a bump or swelling, let alone a fracture, that would be interesting to know. But as I said earlier in my argument, she was not asked that.
No, she wasn't, but Schwartz did testify to this constellation of symptoms, internal symptoms to the baby, and explain that through this diagnosis. So I guess while she didn't perhaps explain how hitting, a baby 10 times or 11 times in the head does not result in bruising, she did explain why the axial injuries, the scarring of old injuries would be inconsistent, the eye injuries, the spinal cord injuries, the shearing that Stanley testified to, how all of those, and the blunt head force trauma, how all of those came together to be consistent with what physicians call AHT. And why is that not helpful? I understand that on cross-examination, she could be cross-examined, have you seen a baby who's been hit 11 times in the head with no bruising? That I understand. But on the Daubert-Lanigan aspect, she was providing something that could be helpful to the lay juror.
I'm not saying that everything she said is inadmissible. As we can see in the brief, if it would be all right for her to say, it's rare for a child to have a fatal hematoma from a fall. And then Attorney DeWitt would stand up and say, well, it's rare for a child to have two neomembranes in their brain, isn't it? So that is permissible. But what she said about rotational force, I thought it was all very confusing, because it seems to me this was kind of canned testimony that she gives regardless of whether it's a pure shaken baby or not. Because she was talking about the weak necks of a baby and their large heads and their soft skulls, stuff that was not quite on point for this 11-month-old child. So I don't know that it was helpful.
You still go back with the helpfulness part, though, that I'm struggling with. Judge Wilkins had an extensive hearing on this, right? Made a determination as to the consistent with to address some of the issues, maybe not necessarily all of them that the defense was concerned about in terms of the ultimate issue, but certainly made the restriction on the Commonwealth it's got to be consistent with. And so Judge Wilkins made a determination after this evidentiary hearing that it would be helpful. So now we're at the point of whether or not Judge Wilkins abused his discretion, that this is completely outside of the realm of what any other judge in that position would do. How is this an abuse of discretion? I understand you might disagree with it. I understand you don't like the final instructions on inferences and all of the inferences that you can draw from the facts that have been proved to you. I get there was no direct testimony that tied the thumping to this, but there is the instruction about the inferences. How is this all an abuse of discretion?
So Judge Wilkins, it appears to me he based his decision solely on the consensus statement, which is by certain pediatric radiologists and others and he accepted that at face value and said this would be helpful because they use it and it's used amongst these members of the medical community. Mm-hmm. But the fact that they use it, again, it has to explain something that the jury would not otherwise understand simply from hearing about the blunt force trauma diagnosis from the medical exam, about the way she presented, about...
Okay, but based on what Justice Wendland just laid out for you, it seems that you're saying that it's only helpful if there's direct testimony. They can't put it together through inference from the facts that have been proved to them, which is against what I believe Judge Wilkins gave as an instruction in the final instructions.
Yeah, really the crux of my argument is this was a straightforward battery case. That was the way it was presented. That was the Commonwealth's theory of the case. And it was not, as I say in the brief, I concede that if shaken baby syndrome were actually a true theory, which we dispute for all the reasons in Yaves, that would be helpful because it's explaining something that you can't see. You don't understand the mechanism. It gives you the mechanism. Here's a baby that is atraumatic, and yet it has a hematoma. How did it happen? So it posits this theory, which has now been pretty much disproved by all the biomechanical studies they've ever done. We have the mechanism here. The prosecutor stood right up in opening, and she stood right up in closing and said the baby was beaten to death against a wall. In which we have plenty of medical examiners and neuropathologists. So Judge Wilkins abused his discretion by admitting this because it was highly prejudicial, because she used the word abuse a bunch of times. I'm a child abuse pediatrician. I have a child abuse credentials and so forth. And it allowed her to opine on the ultimate issue needlessly. And the probative value was nil, I would submit, because it was all either derivative and they'd already heard it, or else it was just explaining something that the jury could already tell with their common sense, that if you beat a child, as the Commonwealth claims, Chloe was beaten, that it would be harmful.
Thank you. Attorney Monahan.
Good morning. May it please the court, Assistant District Attorney Megan Monahan on behalf of the Commonwealth. Where the evidence here was overwhelming and the trial judge did not abuse his discretion in admitting limited medical expert testimony about abusive head trauma, the defendant's conviction for involuntary manslaughter in the killing of her 11-month-old niece, Chloe Chen, should be affirmed. Now, I understand, Your Honors, I expect we're going to spend most of our time on the abusive head trauma discussion, but I just would like to correct a few points made by counsel on the sufficiency of the evidence and statements made. Your Honor, the prosecutor and in the Commonwealth's theory of the case was never that Chloe's head was bashed against a wall 11 times. I would direct the court to the Commonwealth's closing argument, which was suggested that it was a hard surface such as the bed. And the Commonwealth put in volume 2 of its supplemental appendix the bed photographs that the jury saw, the physical bedroom furniture, which had wood frames and thin mattresses. And so, Your Honor, there was no suggestion specifically that it was a wall. So I'm not sure where that came from, but it was actually the bed. And that was one point there. Another I'd like to suggest, Your Honor, with respect to the bruising, I think we touched on Dr. Shaw's testimony, which is on volume 9, pages 19 to 20, 28 to 30, and 39 to 50, about the bruising that came forward on Chloe's forehead. Dr. Schwartz also testified, volume 10, page 1, volume 11, pages 17 to 18, about how it can take 2 to 3 days for bruising to come forward. The autopsy was done 3 days after Chloe presented to the hospital.
So how did Chloe present just visually, as far as, I know there was EMT testimony, but how did Chloe present physically?
Visibly, there was a small bruise on the right forehead. And then she was taken to a CT and there was emergency surgery performed. Dr. Schwartz testified that after the surgery, she was too unstable for the doctors to do a full skin exam. So the first person who was able to really look at Chloe was Dr. Shaw during the autopsy.
And there was evident blunt force trauma in that?
Yes, Your Honor. So Dr. Shaw credibly testified to what he could distinguish as injuries due to surgical intervention versus what he believed was blunt force injuries, and that was injuries to the left and right forehead. I believe there was one on the left cheek, left forearm, and then on the torso. Those bruises he attributed to blunt force injury, and photographs were presented to the jury of those injuries.
Counsel, given that this is that has some scientific component to this, and our independent scrutiny of this isn't just we see to Judge Wilkins on an abuse of discretion standard. What do we make of the fact that there's no biomechanical support for AHT?
Your Honor, with all due respect, the biomechanical studies that have been cited by the amicus and that were in Neves are exclusively about shaking. They do not touch on shaking plus blunt force trauma or impact injury is how I think the biomechanical phrase it. Duhame is cited by the Neves decision and also in the amicus, a 1987 case study that's purely about shaking and whether or not adult human can generate enough forces. Later studies, which were before the trial judge, critiques of that were about whether or not impact would influence it, or the biofidelity of dolls and whether or not those dolls actually mimicked an infant. And so that, Your Honor, I would respectfully say biomechanical studies are not relevant in this case because they are exclusively looking at shaking.
Why should we continue to allow prosecutors to, and forensic scientists to use the word abusive head trauma?
Well, Your Honor, I would suggest that abusive head trauma is not only the widely accepted medical diagnosis and the term that the medical experts are used to, but in this case, the trial judge actually very thoughtfully considered of alternate phrasing, and he asked the parties to submit alternative phrases, including inflicted head trauma, non-accidental head trauma, and head trauma, were, I think, the ones proposed by the parties. Commonwealth, the defense being head trauma, the Commonwealth being non-accidental and inflicted. The judge considered all of those within the testimony of Dr. Schwartz and found that they were not fully encompassing the term abusive head trauma. And I can use some examples if that would be helpful. So if we were to think of non-accidental head trauma, in this case, Chloe was undergone 90 minutes of CPR resuscitation. And part of the defense theory was that the injuries to the head were as a result of those resuscitation efforts. I would suggest, Your Honor, that is non-accidental head trauma, in that it was non-accidental, it was CPR. So non-accidental head trauma is now different from abusive head trauma.
Why couldn't you just use pre-hospital admission head trauma?
Pre-hospital admission head trauma, in the sense, Your Honor, that that would not encompass Dr. Schwartz's full medical opinion and expertise, that this was head trauma inflicted by another person.
I think one of the concerns is, if this is going to survive Lanigan, is now going forward, what limiting principles? Because even if you take the consistent with, and I understand Judge Wilkins was trying to be really thoughtful about that, but at what point, if you take consistent with and then the abusive, the phrase abusive head trauma, at what point does it really become the functional equivalent of causation?
Well, I think, Your Honor, consistent with abusive head trauma was an excellent line drawing in this case, because as Judge Wilkins said, it allowed a full discussion by the experts. And as you saw, both by Dr. Schwartz and the defense experts, they engaged in a full conversation about alternatives, including whether accidental falls could be contributory, whether it could be other rule outs. And so by using that consistent phrasing, there was this full discussion about these, and there was no definitive diagnosis placed forward, paired with the judge's final instructions that the jury decides the case, not experts, and that full instruction. I would suggest, Your Honor, that there was no abuse of discretion, no prejudice here, and that consistent with terminology would be good practice going forward, as this case demonstrates.
Does the medical literature use anything but? I assume the medical literature moved from shaken baby to AHT because that's where the doctors thought there was a better consensus or better scientific description of what they're doing, right? Or
Yes, my understanding, Your Honor, is that shaken baby syndrome was replaced with abusive head trauma because it acknowledged the different mechanisms. Again, like this case, where Dr. Schwartz said it could be acceleration, deceleration forces, it's rotational forces, that's shaking impact or impact. So abusive head trauma fully encompasses that. And
is there any other terminology that scientists are using, doctors are using now, or is that, if we create a new one, are we creating something that's not medically sound?
I did think you were going to ask this question, so I looked in the medical journals, and I saw the alternative phrasing was inflicted head trauma.
And that could be from an EMT, inflicted head trauma, right?
I'm not sure, Your Honor, in the sense that I think blunt force trauma came from Dr. Shaw.
No, but it would also, it wouldn't answer I mean, the problem is pointing the finger in the label, right? So if you had accidental versus accidental, whether something's an accident or not is a legal conclusion, not a, right?
Right.
So the question is, are we going to break this if we try to fix it?
And that's where I think Judge, well, I keep giving him different credentials, but Judge Wilkins, I think in his 17-page decision, thought through that and didn't want to stray too far from not only the case precedent, but where the science and the medical witnesses are at, because it was going to inject confusion into testimony by using different phrases that did not necessarily encompass the expert's opinion.
It sounded like he was concerned as a practical matter that this is the terminology that both the defense experts and the Commonwealth's experts use. And so he decided not to add a different phrase.
Yes, that's a very good summary of the opinion, I would say.
But going forward, what would be the Commonwealth's objection were we to say, just as an evidentiary matter, that the phrase should be inflicted head trauma?
Your Honor.
Is there a pragmatic objection to that? What objection, if any, would there be from the Commonwealth?
I think as it's more of a pragmatic in that the abusive head trauma is the official medical diagnosis. That being said, I have seen, including testimony in this case, inflicted head trauma. So if we were to in any way change or stray, I think that is our best option. But the Commonwealth's first position would be consistent with abusive head trauma as it was in this case.
Is there anything that we could draw on in this record to come to the conclusion that it sounds like you've come to, that there is an alternative way of referring to AHT as inflicted head trauma, and that has also been accepted by the medical community?
I'm not sure off the top of my head, but if there was a discussion, it would be in the Chowdhury consensus statement, which is in the Commonwealth's.
I don't think I need to, I know, I'm familiar with it.
Okay, it's the Supplemental Appendix Volume 1. That would be, I think, Your Honor, where if that is discussed, would be my best guess. The other articles, maybe possibly in the Narang, which are the following ones, would be. But I'm sorry.
Has any other court used the consistent with formulation in this context?
I'm sorry, I didn't catch that.
Sorry, I apologize. Has any other court used the consistent with formulation in this context? I know we use it all the time in the DUI stuff, but has any court in the country done this, or will we be the first ones to do this consistent with formulation for abusive head trauma?
For abusive head trauma specifically, Your Honor, I did not see it in other courts. That being said, in this, I saw that I believe it was Commonwealth v. Epps, where at least it was commented on that was the testimony offered by the expert. That wasn't the ultimate decision of this court, or wasn't an issue before the court.
That was Commonwealth versus what?
Epps.
Okay.
That I believe that was how it was framed. When the Commonwealth was proposing consistent with abusive head trauma at the trial court level, the cases that were considered were child abuse and rape cases were consistent with penetration. So that's where that phrasing came from, was in case precedent.
Can I ask you to please respond to the argument that the defendant made at the very end of the oral argument that, where this case, the Commonwealth's theory did involve trauma, physical trauma to the head of the baby, that expert testimony regarding AHT, much of which does relate to trying to explain injuries from shaking, was simply either cumulative or irrelevant in this context.
Yes, Your Honor. So I think in the defense's argument, they're simplifying the Commonwealth's theory of the case in that it was multifaceted of a mix of swinging, shaking, and impact. And so Dr. Schwartz was testifying about acceleration, deceleration forces, which are the back and forth, we'll say, for layman's terms, shaking or swinging, and the rotational forces, which is from the impact. So it was the culmination of that action that led to such serious injuries and with limited external trauma, particularly where there was microscopic neck injury, there was the massive subdural hematoma, and the retinal hemorrhage that showed significant trauma. How I like to think about the expert's testimony in this case is that they were building blocks on one another, and where Dr. Shaw was able to testify to repeated impact with significant force, Dr. Schwartz was able to add the forces involved of the acceleration, deceleration, the rotational, and why an infant's development, including the underdevelopment of their brain, the oversized head, the weak neck muscles, would contribute to such significant internal injuries with limited external injuries. And so together, those pieces came together for the Commonwealth's theory of that there was a multifaceted swinging, shaking, and blunt force trauma that ultimately ended up killing Chloe. If there are no further questions, the Commonwealth will rest on its brief and its response to the amicus if that's to be accepted. Thank you.